André, I have a question. I think I read in the language of the law that there is provided there an affirmative defense that the sender of the infringing message, as long as the sender was showing a good faith effort to comply with the law at the time of the violation, that that exists as an affirmative defense. Is there any legal test that can be employed to determine whether that effort fulfills that good faith standard, or is that just kind of a squishy?
So you're talking about if you can show due diligence, that you made all the steps required to comply with the law, and there was some form of an unintentional contravention. There are a number of mechanisms that exist in the law, one of them being the due diligence defense, and that common law principles generally rule the day. So if you take every reasonable possible step, and for some reason there was a technical glitch and you just sent to the unsubscribed list instead of the subscribed list, are you going to be held liable for all of those messages? That's why the due diligence defense is built in there. The other one is that there is, and this is going to be controlled by the 3 enforcement agencies, so they're going to be in a better position than I am to describe these, but there is an opportunity to enter into a compliance agreement, to go up and say, look, we had a mistake, we had an event, it was a mistake that occurred. There's no guarantee that you won't be on the other side of a penalty if the enforcement agency finds that you were somewhat negligent, although you say you had the policies in place and you took all the steps. Negligence did occur, so they can still assess damages or penalty in that case in terms of the court or the enforcement agencies, but you can step forward and enter into a compliance agreement in that case.
How does this law help those outside Canada who are recipients of spam originating in Canada?
So the way the law is set up, it covers off both sides of the equation. Emails that are sent from Canada are required to have all of the consent requirements, et cetera, et cetera. So if we have a spammer set up in Canada who is sending, bombarding the US or France or Europe, wherever, with spam, but not necessarily sending to Canada, we wouldn't receive those complaints from Canadians, and the Canadian ISPs likely wouldn't be notifying us. But there is the opportunity for the American ISPs to notify to the Spam Reporting Center, and we're going to look at collaboration techniques with the spam reporting centers from around the world to be able to pick up on that type of stuff. So you could have a spammer in Quebec who only spams to France. Well, we wouldn't see it. But Signal Spam in France might see it, or the French National Police might see it, and they'd be able to notify us. And the action that we take in that case is we're serving, a law enforcement, one of the 3 law enforcement agencies are serving notice in Canada so that they'll be able to serve those penalties in Canada. And there's also the opportunity for the private right of action there again. So it impacts those who are, part 1 was let's clean up our own backyard. So messages sent to Canada and sent from Canada are covered. And then after that is all of those additional mechanisms that we have for the law enforcement agencies to collaborate internationally, or for that private right of action to be found and upheld in those foreign jurisdictions.
Do you have a sense of the prosecution bandwidth? Are we going to be able to put some teeth into this and actually get the guys, or are we going to just talk about how bad they are?
Well, Shaun might be able to go into greater detail, but we opened up that private right of action to allow for things like a class action lawsuit, to allow companies in Canada, not just ISPs. So under CAN-SPAM, it's really limited to ISPs to be able to go after these spammers. In Canada, we opened it up to consumers, businesses, enterprises, and class action suits. So it's a very broad private right of action. And if it's clear, if the plaintiff can prove that there was violation here, the violations are clear, the penalties are such that they can be very expansive, get into the millions of dollars very quickly, and that the likelihood of these being upheld is pretty high. The other thing is that the amounts owing when you owe to the court system in Canada are, you owe back through that. So the likelihood of collecting, even though the people are trying to go and hide the money elsewhere, is fairly high. And in terms of the the law enforcement agencies like the CRTC, when they serve notice, that money is payable and owable to the Crown. So basically they can follow up with the federal court to have the administrative monetary penalties pursued by federal court. It's like, you know, not paying your taxes, so they can pursue that, and you end up with a law enforcement pursuit at that point.
Thank you.
Hey, Andre, just a quick question. If you wouldn't mind clarifying for the audience as well, there was also concerns about frivolous lawsuits also being filed under the private right of action. Would you explain a little bit about Canada's, I guess, stuff on that in terms of how they control that?
Yeah, so there's three things in Canada that we've done to kind of protect. We saw the instance of what went down in Utah, where you had literally prisoners filing thousands of cases in Utah under provisions under the state law there. There are three things. One, you have to file in Canada under private right of action to a superior court of a province or to federal court. Two, that usually comes with a small fee in order to be able to file. Three, in Canada, loser pays. So if you're bringing forward a frivolous lawsuit and you're suing a large corporation, you're on the hook for their legal defense fees, which can get into the hundreds of thousands of dollars very quickly. And in an insanely frivolous type of a lawsuit, the court can actually impose fees for wasting the court's time. So we're not concerned that we're going to have, you know, people bringing forward their neighbor down the street who sent them 10 messages through the court system. It's simply likelihood of that case getting heard is nil to none. Frank?
Yeah, so I think it's time to thank you for your great presentations and for the detailed replies you're providing here, which doesn't mean that I'm wrapping up anything here, but I always got every query answered because I waited until the end. So one thing I noticed at the start is that you said that the Spam Reporting Center is taking complaints from Canadian citizens, and now you said, of course, that they are taking also complaints from entities abroad, and you're also processing complaints that are referring to emails that have been sent out from Canada to entities abroad. So, which is good, because we are also operating at ECHO, a spam reporting center, and there might be a possibility to cooperate and so forth. The question always is, for example, under the e-commerce directive in the EU, you have a reversal of the burden of proof, not a reversal of the burden of proof, there's two also, but a reversal of the legislation that applies. So the legislation applies of the country of the recipient, actually, and not of the country of origin. So in that case, you probably will have to know at least all the 27 regulations in Europe, if there are differences under the e-commerce directive, plus any other regulations around the world. Is that feasible, or?
What we've done in terms of, there's kind of two parts to that question. So one is, if I'm going to bring a case forward in Canada against a spammer, let's say he's in Nigeria, do I have to have a really good understanding of the Nigerian law? The general principle is no, as long as there is a law that addresses that activity in Nigeria, the finding from that private action will likely be upheld. The case in Canada that I talked about, the Facebook case against Guerbez, is we didn't even have legislation that was passed when the Quebec Superior Court upheld that decision, which goes to show that, you know, you can sue a spammer in a country that doesn't necessarily have anti-spam legislation and still have that finding upheld, because courts will find and uphold decisions in foreign jurisdictions regardless of the law in the domestic jurisdiction. So it can happen. I say the likelihood likely will drop significantly. If they have a spam law and you sue them under the Canadian legislation, Canadian courts, it's likely to get upheld. The likelihood will drop off if they don't have a spam law.
I think the practice will show, actually, and the parties you're working together with long-term, you will have to have practice with. A quick comment to documenting actually the consent. You said that it's also allowed to get oral consent or other forms, you know, and document it is very difficult, because you have to keep recordings and so forth, and it's always a question how you actually can document a consent and prove that you have the consent. I just want to comment that in Germany, for example, the combination of the burden of proof that is upon the sender and the possibility that you get a statutory declaration from the complainant always clears up any case, because as soon as you're going to the complainant and ask him to give a statutory declaration, which is punishable if you give a wrong one, then either you don't hear from them anymore, or they give it and the sender actually, says, yes, it's true, and we made a mistake, and whatever. And in practice, you don't have these problems that you have to record all the consents that in that detail, but it's statutory declaration sometimes helps.
You want to comment on that? There's another question there.
While we're speaking about consent, from an ESP perspective, I think it's pretty clear that if the ESP has a sign-up form, they will have a record of the consent of the recipient. But is it required for the ESP to maintain it when their customer imports their list of recipients? Is it sufficient to have them select a box that says, yes, I have consent from all of these and I have a record of that consent? Or must the ISP also have a copy of that record of consent, including, you know, the sign-up method and all that kind of good stuff?
Well, if I understand the question, you're saying when you're allowing one of your clients to import their list, are you taking on liability if you also don't import some sort of evidence of consent?
That's correct.
Correct. So the ESP in that case shouldn't be the sender. The client is the sender, so they're the one that's ultimately responsible for having that evidence. Not to say that you don't want to encourage your clients to make sure that they maintain proper records, but you also want to be careful about potentially taking on liability by taking on some of that responsibility yourself as well. So you want to make sure that you educate your clients and make sure that they're doing the right thing, but depending on the level of services that you offer, you also want to be careful about potentially taking on that liability on their behalf.
Question up here.
Since CASL's intent is to be regulatory and not penalizing per se, will the spam collection repository that you manage be transparent in a way that enables ESPs to learn about spam that is being reported that originates from that ESP's customers, so the ESP itself can act as a middleman to police their own customers?
We're reviewing some international practices in terms of spam reporting now. So we know that the French Signal Spam allows for ESP and ISP access, so they can figure out, who and when and where and how people may or may not be crossing the line into that space. The issue we have in Canada is that the Spam Reporting Center is being collected. The reports are being collected by the federal government. So we'd have to be able to anonymize all data, but there's no framework in place yet. We're still going through the process of establishing. It'll be established at the CRTC, so there's no way of knowing whether the CRTC is going to choose yes to provide notifications to ESPs and ISPs when they may or may not be crossing the line. But I wouldn't be surprised if they did. But you'd have to follow up with the CRTC, who's going to be hosting the Spam Reporting Center, to just say, look, in case it ever comes down the pipe, the goal of the legislation is clearly that we want everybody to be compliant. If any of our members go offside, would you let us know? That'll be up to them ultimately, but I wouldn't imagine, as long as they're not divulging any personal information in specific accounts when it might be happening, I wouldn't see why they wouldn't be able to do that.
Yes, I can see that good ESPs have a vested interest in policing their own customers, and this collection point might be a useful way to provide that kind of information to those who really care.
Yeah. A question over here. Go ahead.
You had mentioned, or we had covered that it would be 3 years of a grace period when the legislation takes effect. When is that expected to be?
So if you have an existing business relationship or an existing non-business relationship ahead of coming into force, that relationship is grandfathered for the subsequent 3 years after coming into force. So if we have a coming into force date of January of 2014, January 1st, that existing business relationship or existing non-business relationship allows you to imply consent for the following 3 years up until January 1st of 2017.
So is that the date that's expected?
We haven't got a specific date yet until we finalize the regulatory environment and then provide a a period of time after we finalize the regulatory environment to allow companies to become compliant. We won't know. When we do publish our final regulations, which is looking like early 2013, the specific coming into force date will be pronounced.
Is there any provisions in the legislation for list brokers, people who basically purchase with consent or accidental consent, trade shows, any of those kinds of events that, you know, that would typically be selling for postal but have also got into the business of electronic?
There are two, and we didn't go through the law in any detail, but you'll see these come up in the videos that we've already got posted on the MAAWG website. There are two exceptions to the requirement of consent for things like trade shows, and one of them is conspicuous publication. I publish my email up on this board. I publish it in a trade magazine on a website. As long as what you're sending me refers to my business role or function, you're exempt from the consent requirements. The unsubscribe and ID still required. The other one is disclosure. Right now I take out my business card, I hand you my business card. So it's the same thing at trade shows. You got the bowl out. People are disclosing their email address to you. Again, it's accepted from the requirement to have consent, but you need the ID and unsubscribe, and it's got to relate to the relationship. So I gave you my business card knowing that you're an ESP or an ISP. That's one thing. I don't want to hear about, again, the Viagra type pharmaceutical sales. So you've got to limit it to the business relationship again.
So I'm curious about how you determine who counts as sending from Canada. So for example, if a Canadian business that has their headquarters in Canada contracts out with an American ESP whose all of their servers are in the United States, would they count as sending from Canada, or would they only have this count for them for recipients that would be in Canada?
The way the law is written is it says that it'll apply to any commercial electronic message sent to or from a computer system located in Canada.
So if all the servers are in the United States, and then it would only count for people where the recipients are in Canada, but not every other recipient because the message is officially not sent from Canada?
Potentially, yes. I don't want to say yes, absolutely, because there's all kinds of granularity in there that could influence the question, but potentially, yes.
Okay, thank you.
We can talk about this more offline.
Going back to his question in regards to trade shows and things like that, so you then have the email address of that person, then do you, from that point forward, you have 24 months to get them to get the opt-in, correct?
Yeah, so if you look at the provisions are in section 10 sub 9 sub B and C in the legislation regarding conspicuous publication and disclosure. That allows you to imply consent again. So if it's in the case of I hand you my business card today, you have the following 24 months to send me those commercial messaging seeking my express consent, or just sending and offering the unsubscribe. So I can unsubscribe at the first message or any subsequent message.
So this is a follow-up question to the private right of action. Is there another law in Canada similar to this where individuals can take private rights of action against, other third parties in like different law, not anti-spam law? Especially ones where pretty much everyone in Canada gets email, so potentially, everyone could be, involved in one of these suits.
There are, not in any of the areas that I really practice, so I'm not really familiar with them, but I think it's safe to say that none of them are potentially this potent, both in terms of the breadth of the application, in terms of who it applies to, as well as the ability to sue for statutory damages that could apply so broadly. So this is, in a lot of ways, I think, a fairly novel thing to see in Canada.